Hello, I'm Jean Pete, and I welcome you back to our show, Better Living. Better Living is brought to you by the Homestead Hope Foundation and is sponsored by Homestead Hospice, where commitment to education and premier hospice care helps patients and families through life's most important journey. Thank you for joining me again this week. I'm Jean Pete, and I'm here today with Barbara Parker. Barbara is you could hear my Boston accent come out just then, didn't you? I know you did. Anyway, we're here with Barbara Parker, and Barbara Parker is an attorney who specializes in wills, trusts, and estate planning. And so stay tuned because she has very special expertise. She was a CPA and then decided she wanted to become an attorney. So any of the other attorneys I've interviewed in the past have always, whenever I delve into the tax questions, they always say, well, I don't know, they'd have to seek their tax accountant out for that. So we've kind of got a one-stop shop guest here with us today. So welcome, Barbara. Thank you for joining me on the show this morning.
Oh, thank you so much, Jean. It's great to be here.
So let's talk about that. How did you get involved? How did you decide you wanted to be an attorney specializing in wills, trusts, and estate planning?
Okay, well, I did hear the Boston accent because I went to school in Rhode Island and I studied accounting and then passed the CPA exam and, thought I needed to stay on that path. So while I was working, I got my MBA in finance, and that still wasn't doing it for me. So what ended up happening is I kept getting pulled into legal issues related to the financial issues. They kind of go hand in hand. And I said, gee, this is really neat being able to combine the two. So in my mid-30s, off I went to law school.
Wow.
So, yeah. And while I was there, I decided I have a 16-year-old daughter, and I had her my last year of law school. And I said, okay, how do I balance everything and, do an area of law that I'm very passionate about and use all my skills and have time for my family? So that's how I ended up doing wills, trust, and estate planning, and I love it. I love it.
There's two whole other shows in what you just said. One in following your passion, and when you're passionate about what you do, the rest just kind of falls into place.
It does.
And two, in that whole work-life balance thing with career women, I got to do a show on that because I don't know if we can have it all. I think we have to have it all in pieces, or maybe a little less of this area so that we can focus a little more on this area for now and then swap it when we get older, or I don't know. But that's a whole nother show for a whole nother day. Let's talk about wills, trusts, and estate planning.
Okay.
So what is the age of your typical client?
Most of my clients, quite frankly, are in their 60s or 70s. A lot of people come to me, with their heads down saying, I've never done this, or saying, heads down again, I did this 25 years ago and my kids are grown now. So they're dealing with their own mortality. So those are, I would say 80% of my clients are in that age range. But, it's interesting. Their kids should also be doing their wills, because one of the most important things that you can do with a will is say who you want to raise your minor children.
Well, that's what I was thinking as you were talking. It's so sad that it's 60s and 70s, because when you've got little kids, if something happens to you, you've got to have a plan in place.
Absolutely. Absolutely. And so many people say, but I don't have anything. Well, yes, you do. You have your kids. And who do you want to raise those children?
Right. And you don't want them to get locked into the governmental system while they're trying to figure out what to do with them. And I've seen that happen.
Absolutely.
And just healthy people. My friend died of that MERS virus that went around 5 years ago, and she had lost her husband 2 years before to a heart attack. So these were young, vibrant, healthy people, and all of a sudden there's two little boys who have no parents and no plan.
Right.
And it's sad. So yes, if you're in your 60s and 70s and don't have estate planning tools and things written down so that people know what to do with what, that's important. But if you're raising children, you really need to have a plan written down, in place, notarized, legal, so that your kids don't get stuck in a court mess.
Exactly. And even, it's not all about if you pass away. Part of what we do is, the
SARS virus. I said MERS. I'm sorry.
That's
sorry.
okay. That's
anyway,
okay.
So go ahead.
Part of what we do when we do the packages are the financial powers of attorney and the advanced directives for health care. Because at least for me, when I pass away, I'm gone. But, if something happens to me, if I'm out on the highway and I'm in an accident and they take me to the hospital and I'm in the hospital for 2 months, then somebody else has to carry on for me. Somebody else has to pay my mortgage, has to do my income tax return, has to make healthcare decisions for me if I'm not able to do so. So that's part of what we do. And
so important, and I'm so passionate about that as well. I am not a lawyer, but anyone I ever talk to I tell them all, get your advance directives in order. But before we go there, I do want to talk a little bit about wills and trusts related to what's best if you're raising children. Do you do a will? Because I thought you were supposed to do a will. I got a will, and it's inexpensive.
Right.
So it seemed like the best route to go, because when you have kids, all your money's going out the door.
Right.
But then someone said to me, and I think it was a few years back on a show like this, they said, you really should have that in a trust.
Okay.
And so I'm all confused because I don't know. Okay, so does the trust trump the will? How do you put your will in your trust? How does that all work?
That's a big area of confusion, and you can accomplish mostly the same things with the will and the trust. There are a few reasons why somebody would do a revocable living trust. The goal of a revocable living trust is to prevent your will from having to go to probate, because technically you don't own anything, your trust owns it. And they're very prevalent in states where the probate process is cumbersome or very expensive. Southwest, they're doing revocable living trusts all the time. In Florida, I see it. When clients come to me, we discuss the pros and cons. The one time I strongly recommend that someone use a revocable living trust is when they have real estate in multiple states, because you have to probate your will in every state where you own real estate.
Okay.
So that can become very cumbersome and expensive.
Okay.
So then I strongly recommend a revocable living trust. But even when you have a revocable living trust, you do a will alongside it, so that if there's anything that you didn't put in your trust, then it'll be governed by the will.
So you name the will in your trust, and then it's according to the laws bound by the trust, but you're covered.
Well, what happens is the will, it's generally referred to as a pour-over will, and it basically says, do everything the way my trust said to do it.
Okay.
But in the trust is where you're going to name who your successor trustees are, who would distribute your assets or maintain the assets for the kids, for their expenses.
And let's talk about that.
Yes.
Because I do think, however unfair this might seem, or against public opinion it might be, I don't know, the folks that you choose to raise your children might not be the best folks to handle the assets that you left for your children.
Absolutely. And that's okay. That's okay. And, my accounting background, we call that separation of duties.
Yeah.
For those auditors and financial folks out there. But oftentimes that's the case. Somebody who's really good with healthcare or with raising kids is not great with money. And that's fine. You can name one person as, or a series of people as the trustees to manage the money, and you can name somebody else as the guardian of the children, and then the guardian and the trustee will work together.
You hope.
Exactly. Hopefully.
So be very careful in your planning.
Right. And that gets to another point that I strongly encourage that people talk to folks before we put things on paper and, before anything happens, because we want to make sure everybody's on board. Mm-hmm. So that's really important too, because for everyone going in with eyes wide open and knowing what the plan is and what the different roles and responsibilities are going to be is key.
So, so we've talked a little bit about wills and trusts. What are the top 3 things you want people to know about a will? And then we'll get into trust, and we'll get into healthcare proxies and advanced directives and all of that. Let's try to simplify everything for folks.
Okay. The let's see. First and foremost, I think it's very important that people understand that there are things that they can do outside the will. And in fact, when we pass away, there are 3 ways that property passes, and the will is only one of them. Okay. The other ways are ways that people can manage on their own without working with an attorney. And one is, it's critical that you look at your deed if you own real estate and you're married or you own it with somebody else. You can title it joint tenants with rights of survivorship. And by titling it that way in Georgia, it's different. It's a little bit different in every state. But by titling it that way, by law, when one of the people passes away, it automatically goes to the other person in its entirety. So that property is not available for creditors to collect against.
Okay.
And that can come up. It can be a huge issue. I've had it come up a number of times in my practice. And we can deal with it on the back end, but it's more expensive and it's a lot more troubling and stressful. It's easy to deal with that up front. You do a deed, changing it to joint tenants with right of survivorship, and then you've got the property passing, at least with a first person passing away, without it having to go through probate. The second thing is accounts, investment accounts, IRAs, 401ks. They have beneficiary designations. I think a lot of folks every year when they sign up for benefits, they say, okay, these are who you've designated as your beneficiaries. It's critical to keep those up to date. And don't just name one. I have a lot of folks who say, well, yeah, I put my spouse. And I said, well, what happens if something happens to both of you? Then it's got to go through the probate estate.
Don't you have primary and secondary beneficiaries?
Yes, you can.
Okay.
You can. So it's important to name the primary, the secondary, and even a third beneficiary.
But that's so important because that's things we forget about. I had a 401k, 9 years ago. I just realized I put my spouse with my kids as secondary, and I'm no longer married to him. I think it might be time for me to call up and get that changed.
You might want to change that. But think about it. So we've talked.
You forget about it.
You do. And that's why I bring it to the attention, of all my clients, because it's so important. I had somebody who passed away, named his mom. She had died 10 years before he did. And instead of what the process is, if there's a live beneficiary, they submit the death certificate and proof that they are who is named as the beneficiary, and they have access to the funds. If it has to go through the probate process, you have to get the petition done. It just takes a lot longer.
And probably more money.
And more money. Exactly.
Wow. Okay. So get your beneficiaries right on your investment accounts.
Yes.
And get your will in order.
Yes.
And what else?
And the real estate. So think about it. We've talked about the deed. We've talked about the investment accounts. Where, for me, that's where most of my equity, most of my assets are, and those things. And I've tackled everything. The only thing left to cover by my will, if I've done everything correctly, is my stuff, my personal property. And while that may have sentimental value, that's not where the big value is in terms of my assets. Mm-hmm. So, and then...
So when you're doing sentimental value, your stuff...
Yes.
Is it better to do that in a will? Is it better to do that in a trust?
Again, the trust you want to do if you've got real estate in multiple jurisdictions, but you can do it both in a will or a trust.
Okay.
What I typically use is I have an attachment where, I've got a lot of times people now they're not so hung up on sentimental value, so they'll say, split it evenly among my kids is very common. But I've had people with 3 pages of detailed information about specific items going to specific people. You can do it either way. It's whatever works best for you. And we write language into the will so you can update that on a regular basis, ask your executor or trustee to honor it, and then you don't have to go back to an attorney every time you want to change it.
I'm in the camp. Be specific about stuff that your family's going to care about. Don't just say split it. That's the easy way out. And what you're doing is you're leaving a gift for your family. Because too many times, I've worked in hospice a lot of years, and too many times the person that's sick is the glue. And when the person dies, the glue is gone. And then when you start divvying up assets or whatever, there hasn't been any conversations. There hasn't been any details worked out. And you're just leaving the door wide open for your family members to have a rift.
Absolutely.
And so for me, I don't care if it's 3 pages long. My grandmother taught me that. She was 92 and she said, Jeannie, dear, what do you want when I'm gone? And my answer was, I don't care, Nana. I don't want anything. Don't talk about it like that. Well, now, Jeannie, I'm in my 90s. I'm not going to be here forever. And I said, I really like that picture of you in your wedding dress. And she said, well, I can't give you the one with Papa because that's going to Michael. But that picture is yours. And it was nice to know that I didn't ask for anything of value, but and that's hanging up in my house today. And I look at it often when I get my coffee and I sit in my front room and I look to the right, and I was very close to her. There it is. That is of the most value to me. I don't care if everybody got everything. Her wedding ring didn't matter. But because she had that conversation with me beforehand and with all of her grandchildren, we all knew. Well, that one's going to Michael. Well, I would have liked to get one of her and my grandfather, but it's okay. And what a gift she gave all of us, because it was clear. Oh, no, Nana said she's getting the engagement ring. No, Nana said she's getting the wedding ring. We just knew. Those were her wishes. You can't fight with that.
Right. And that's going back to have those conversations beforehand. I tell my clients, look, if you want, we'll get everybody involved and we'll have them here and we'll go through it and answer questions because, having the information, it empowers everyone. And it's interesting, you raise a great point. Similarly, I have a great aunt who's in her 90s, and she is very much an inspiration for what I do. And there's a portrait of her. And I was kind of bold, and I said, Aunt Mary, I said, where's that portrait of you? And she said, oh, it's in storage. I said, I would really like to have that. That's the one thing that represents you for me. And she gave it to me. She had my uncle go get it out of storage and gave it to me.
Yeah, you don't even have to wait.
Yeah, you don't have to wait. If it's not something they're using, it's not something that's around, it's sitting in storage, but it has meaning for you, ask for it. They're probably, and I think she was really touched that I wanted it so much.
Yeah.
So.
Yeah. But really, you have to have those conversations.
Absolutely.
And they're difficult conversations to have. One thing you did say, though, is we could bring all the family members around and we can discuss it and talk about it. I'm in the camp. Write it down, work it out. It's your life. It's your stuff. You decide who wants what, and then you can talk to them and see if that's important to them. Or have those questions like she did with me. I think she got us all individually. Listen, I'm not going to be here forever. What do you want?
Right.
And someone wanted the hope chest, someone wanted the bed set, and I was like, yeah, no. Keep all that stuff.
Oftentimes I offer that up, especially if they think there's going to be tension, and it kind of takes the pressure off my clients and puts it on me.
Yes.
And that helps. That I think that helps a lot of folks in that situation.
You know, death is a crisis situation, especially if somebody is sick, even if they're not sick. But when they are sick, there is a gift in that they can plan.
Yes.
Plan for the rest of their life while they're sick and what happens after they're sick and their legacy. And, you know, everybody wants their family to be together.
Right.
And free of conflict. And so I'm such an advocate. I am so passionate. I've learned from the best. I honor my grandma. She was one of the smartest women I know, career woman in the 30s.
Oh, wow.
But please have those conversations. Have that thought process. It's very, very difficult. I worked in hospice a long time. It's difficult to admit that you have a terminal illness that might take you. And that doesn't mean giving up hope that you won't beat it. But you have got a gift to leave, a legacy to leave for your family, and that is to keep them intact. And so have those conversations, get your affairs in order. Don't wait for the crisis to get it taken care of. And we have so much more to talk about. We've only just begun to touch the tip of the iceberg on wills and trusts. We haven't even talked about estate planning as a whole or taxes or anything like that. But if there's one thing that I leave you with today, that is get your plan in order and communicate your plan to your family members and have copies of it in different places. And let your family members know who's getting what so there can be no question. Again, I just want to get your information out, Barbara, before we start delving into more, because you and I are such good talkers that we'll forget. We're talking today with Barbara Parker. And she is an attorney right here in the Atlanta area. She works out of Hickory Flat Highway in Canton, Georgia. And she can be reached at 678-880-0800. And you can also check her out on her website, which is Barbara at attyparkerlaw.com. Barbara at... Oh, that's your email.
Yeah.
I'm sorry. Your website is www.attyparkerlaw.com. Did I get that right?
You got it.
Thanks for being patient with me. So I'm so thrilled with what you just said about, you know, it can be 3 pages long. You can say just divvy it up amongst themselves. But if you're going to do that, have those conversations with your loved ones. Help them while you're still here.
Absolutely.
Have group conversations so that more than just the 2 people that might fight over the one thing they want, hear what your wishes were. So there's clarity, even if it's not in writing.
Right. Exactly.
Which we want to get it in writing,
Yes.
but at the very least, have a group conversation. Let it be known. Well, we have to take a quick break, but we will be right back, and we will talk a lot more about probate, elder law, business startups, nonprofits if we can get to it, and most importantly, estate planning. So stay with us. We'll be right back. Hello, I'm Jean Pete, and I welcome you back to our show, Better Living. Better Living is brought to you by the Homestead Hope Foundation and is sponsored by Homestead Hospice, where commitment to education and premier hospice care helps patients and families through life's most important journey. We're back, and thanks again for staying with me this week. I'm Jean Pete. Still. And I'm still here with Barbara Parker, who is an attorney. We've talked a lot about wills and trusts in the first half hour of the show, and how important it is to get your plan communicated and in order, and what a gift that is to your family if you are sick and suffering from a terminal illness. And we all hope that miracles happen. Nobody ever knows when any of us will take our last breath. But that does not mean we shouldn't have a plan and communicate that plan to our family so that we can leave them with the peace of mind that who gets what was your wishes. Isn't that right?
Exactly.
Okay.
Exactly.
So let's talk about estate planning. I think that's a good segue into the big picture. How we
Sure.
use the wills and trusts as tools in our grand estate plan. What else do we have to think about when we're thinking about estate planning?
Well, estate planning is you know, there's been a lot of churn, if you will, in terms of estate taxes. And while some states have their own unique state estate tax that's different from the federal estate tax. We don't have that here in Georgia. It's just the federal estate tax we have to be worried about. And right now, that is for a married couple, it's over $10.5 million, 5.3 for a single individual. So luckily, and
wow,
yeah, it's
so there's one instance where we're not getting taxed through the nose.
Well, and the thing is it used to be it was $1 million. And then it was going up, and there was it was fluctuating, and the feds really had to get their act together. And so they finally set this up. And I was really happy to see it land where it did because, a lot of us know the millionaires next door, right? People have worked long and hard their entire lives, and they've saved money. And they hit that $1 million threshold, and it was just like, gosh, and there are ways to plan around it. What I've often said is, if people do the planning, there's really no reason that they'll have to pay a state tax. There are things to do to plan around it. But fortunately, a lot of people don't have to do that tax planning anymore. What comes up a lot for me now is people doing lifetime gifting. And this gives me the opportunity to clarify some things there. There are, from a federal tax perspective, there are taxes on estates after you pass, and there are taxes on gifts that you give during your lifetime. And it's not paid by the recipient of the gift, it's paid by the giver.
Gift giver.
Gift giver. So right now, an individual can give lifetime gifts of up to $14,000
Oh, is it
per
14?
year. 14 now. $14,000 per year per person.
Per person.
Per person.
Great.
So, and a married couple, double it. They can each give a gift of $14,000 to an individual. So I have a number of clients who are wanting to give real estate and wanting to, above and beyond the 14. If you keep it at the 14, you don't have to complete a gift tax return. If it's above $14,000 to an individual, you do prepare a gift tax return, but it's an informational return. You're not going to have to pay any tax then. What happens is at the time of your passing, they'll say, okay, let's just create some numbers as an example. Say the estate tax threshold is $6 million. So they say, okay, your threshold is $6 million. You gave a gift during your lifetime of $200,000 to your son. We've got that gift tax return. So now your estate tax threshold is only $5.8 million.
Oh, okay.
So it's just adjusting the estate tax. So
for those real poor folks that are right there at that $6 million range, they better get a little generous for their own good.
Exactly.
Yeah, I'll give them my address.
Exactly. Yes. So, but I've had a lot of people who are very concerned about, am I going to have to pay, I'm going to make this transfer of real estate. Am I going to have to pay out, a tax on that? And it can just be used to adjust your estate tax threshold when you pass away.
That's great. And so what other tips do you give folks who are saying, I really should get an estate plan in place, but I don't really know what that means?
Right. Well, what we typically do is we have a checklist that we use, and I'll offer anybody who's interested in receiving it, just email me or give me a call.
Is it on your website?
It will be. My website's under construction right now.
That's great. Just to remind you all, that's www.atty parkerlaw.com. That's a great tool.
Yes.
And so explain what that is.
Yeah, what it is whether you work with me or another attorney, there's information that we're going to need to prepare your documents. There are decisions that you're going to have to make. We've talked about some of them. Who would my executor be? That's the person in your will who's going to distribute your property after you pass away. So that's going to be, you want somebody who's diplomatic because they're going to have to be dealing with the family members.
That's right. And it might not be a family member.
It may not be a family
member. And a lot of times that's not a bad idea.
I agree completely. You want somebody who's good with money. So you're going to need to think about who you want that to be, and backups too. Because one of the things is we like to, I don't want to, prepare my documents every year and have to update them every year. So the more backups that you have named, the more often you can say, oh, this person has moved to Europe. I don't have to worry about that because I've got 2 other people named as a backup who are still here and are willing to do that. So in addition to your executor, if you want a different person to be trustees, for example, if you set up a trust that's going to come into existence when you pass away, if your kids are minors, which I strongly recommend, by naming the trustee for minor children in your will, you do a couple of things. The money then will be distributed to the trustee as the trustee, and you don't have to go through the court proceedings to get a guardian named, which can, again, be very costly and cause stress and friction among family members. So that's something you can do right there as well. The checklist will also help you think about things that you might even not think about. For example, I have a lot of people who are animal lovers and they leave their pets to someone who they know will care for them or will take care of getting them placed in a good home and some funds to care for them.
And that is so important. People don't, and to do that, not even in the case of death.
Right.
But if you have to go into the hospital and God forbid need to go to rehab, you could be months out of the home. You have to have this outlined and communicated so that God forbid if you're driving down the highway and you have a little mini stroke or whatever, they know, he's got a dog and we've got to get that dog to so-and-so. That is forgotten. Not as much case in death, but in event of illness or accident or some kind of catastrophe, who's going to get that animal?
Right. And that kind of comes back to the financial power of attorney, a document that, that is effective during our lifetime. You need to have the conversation with that agent so he or she knows, look, I've made arrangements with this person to take care of my dogs, or will you take care of my dogs or my cat or whatever, just to make sure they're cared for until you're back up on your feet and you can care for them again.
And just like everything else, you may think you know the right person to take care of them, but if you don't communicate it, you don't really know if they'll take them.
Right, exactly.
And so communicate that, hey, if anything were to happen to me, could you? Because they may say yes, they may say no, you might need to go to plan B.
Right.
This is your life and the life of the people you love and the animals you love. And so communicate.
Exactly.
And not enough people do that.
No. And one of the things, one of the misconceptions that people have is with the financial powers of attorney and the advance directives, it's my husband, it's my wife. I don't need that. You absolutely do. I have a friend who her husband had an aortic aneurysm, and they took him to one hospital, life flighted him to St. Joe's, and she went back to the first hospital to get his medical records, and they would not release them because she did not have the advance directives. So.
Very important.
It is.
And not only that, but as we're talking about advanced directives, first of all, did we hit everything? Let's keep on estate planning because I want to spend quite a bit of time on advanced directives. I'm kind of opinionated on that subject.
Okay.
What else do we need to know about estate planning? What else is important?
Thinking about who you want the decision makers to be and who you want to perform the different functions. Also thinking about those minor kids. When do you want distributions to be made to them outright?
What do you recommend? We were talking about Prince Harry getting his distribution at 30.
Well, and you can't give an outright gift to a minor, so someone under 18. But for me, in my situation, I'm not going to give everything to my daughter when I'm 18. That would be, a pretty nice sized party, and I'd like her to hold on to some of it a little bit longer than that. So what I've done is I think I've spread it out so that she gets a third at 25 and half of what's left at 30 and then the rest at 35.
Oh, that's a great idea.
Yeah. Mm-hmm. And, but people, you can choose.
You don't even think about that. You can cut it into pie.
You can cut it into pie. Things that are important to you. For example, if you want the child to graduate from college or a higher learning facility, a tech school or something, give them something at that time, if you want them to be able to have
And you can say specifically for further education.
Exactly.
And then they have to spend it on getting that education.
Well, yeah. What the magic language is with the trustee is going to make distributions for that child for health, education, maintenance, and support. So it's the trustee working with the guardian and then the child. And then, then the distributions are going to come to the child when they meet these goals that you've set out in your documents. And again, that would either be in your will or in your trust. So, that's something else that you need to think about is when you want those distributions to go to the kids. Do you want them timed so that the kids get all their distributions at the same time? So you can say when the youngest reaches 21.
Oh, yeah, that's something to think about, isn't it? Huh.
Right, yeah. Or, when they each individually hit a certain age or a certain milestone. So that's something to think
I like
about.
the idea of giving a little when they're a set age and then a little more as they get older and a little more as they get older. Because no matter what that dollar amount is, when you're young, you don't really know what's important to spend your money on.
You don't.
You really don't. And you end up with a lot of stuff that you're not going to use later.
And the thing is, say you're 21 and, you want
the Coach bag and the fancy shoes and to shop at Ann Taylor and Neiman Marcus. Then you get a little older and you got the kids and Ann Taylor and Neiman Marcus turns into Kohl's and Bell.
Absolutely. Absolutely.
And you don't need it.
And the kid's going to work, the child's going to work with the trustee to say, okay, what's reasonable here? And hopefully, giving a little bit and then letting the rest of it will hopefully grow so that in 5 years,
that's right,
it's going to be more. And then 5 years after that, there's going to be more. So it's, for me, it works for me, and it works for a lot of my clients.
Yeah, I don't see how that wouldn't be logical for most people. Yeah. So that's a great, we don't think of that. So thank you so much for being here today, because that's what I get to do. I'm blessed to be able to educate and inform before a crisis occurs so that we can all plan for a better life. The show is called Better Living, and I think you just helped us to live a better life. Because we're so busy in our day-to-day, we don't even think about that. I don't even think that I would think about, I could give them at 25, 30, and 35.
And that's kind of what the checklist will walk you through. And again, that's information you're going to have to deal with and make decisions around, whether you're working with me or anybody else. Mm-hmm. So that can get you started. That can really...
And I love that you're willing to share that.
Oh, absolutely.
Because there are a lot of attorneys out there, and I'm not going to bash attorneys because y'all are necessary. But that, that's time that could be billed. Wow. And so how nice is it that you're willing to share that to get people pre-planned and so that they can have the real conversations with you and they've had time to do their own thinking.
Well, one of the reasons that I practice in the area that I do is because my mom passed away when I was 26, and I was her executrix. And we knew, we had time to plan, and it was, believe me, it was extremely difficult. And what coming out of that experience, even before I went to law school, I knew that I wanted to help people make that a more palatable experience, to take as much stress and pain away from it as I can. And so anything I'm able to do to share with people to help them plan for that time, it gives me great joy. So I'm happy to do it. I, do a lot of presentations in that, because I think if people have the knowledge and they understand that the process really isn't that difficult. There's some difficult decisions, but if you have somebody to walk through it with you and guide you and give you the pros and cons and tell you, one of our biggest traps in life is that we don't know what we don't know.
That's true.
But if you talk with people who know a little bit more, they can give you some insight and help you make those decisions and make it easier.
And I think one of the things we need to talk about, you had mentioned that your typical client is in their 60s and 70s.
Yes.
And I think it's because when we're in our 30s and 40s and sometimes 50s, we're still running to keep up with life.
Yes.
And we just don't think about it.
Right.
And we never think that we have enough to get an estate plan in place. And so I'd like to talk more about typical clients, because,
Sure.
We've kind of joked and talked about that person reaching that $6 million gift
right.
Parameter. I don't know a lot of people that have $6 million.
I don't either, quite
And so
frankly.
I don't want to set the stage that you have to have millions of dollars to go and be prepared and have an estate plan in place. So for the average Joe,
right.
what is the typical cost of getting an estate plan in place? And worth. What is the typical worth where it is important to get an estate plan in place?
The for first of all, even before talking money, if you have children,
right.
We talked a little bit before that the people say I don't have anything. Well, if you have kids, you do.
Right.
So that's definitely.
And it's just a will or a trust. It could be as simple as that.
Yes.
And how much does something like that cost to put together?
Typically, our packages include the financial power of attorney, the advance directives for health care, a HIPAA release so that the information about your medical condition can be released to your agents, and the will, and then if you're doing a trust, the trust. For a single individual, the will package usually is around $350 to $500 for those documents. For a married couple, it's a little bit less. It's usually around $500 to $750.
And that's nothing.
And
in the grand scheme of things.
Yeah,
that's not a lot.
Those are the wills, and then the trust is a little bit more. It's like around between $1,200 and $1,500. But then that's when we're dealing with real estate and property in multiple jurisdictions, and it depends on the facts and circumstances. But it does not have to be expensive. And I will tell you, I have people all the time who say, but I can go buy the software for $20, or I can do it online. And that's true, you can. And sometimes you may draft the documents perfectly, but you don't execute them correctly. We've had situations where people have brought us wills, the person's passed away, the person creating the will, the testator, signed as a witness, and the witness signed as the testator. So there are just opportunities for error there because you don't know what you don't know.
Well, and just the thought process as a whole, just sitting here with you, the reason we go to doctors is because they know better than we know. We can throw, medicine in us, but they can get us better.
Right.
when all our attempts fail. They know more. Same thing with you. And honestly, I'm a proponent. I have a background in the financial industry, and I tell everybody to invest in their 401k. But if you're investing in your 401k, I would even tell you above that, stop investing for 6 months and take that money and go get yourself an estate plan, because these are your children that you're talking about, and this is your legacy. And then you can start investing in your 401k again once you've paid that $350, $500.
Right, exactly.
Okay, so we don't have a lot of time, and I do want to talk about advance directives.
Okay.
Because this is so near and dear to me, working in the health industry for such a long time. Do not choose someone to decide whether or not they need to pull the plug, take you off life support, who is not capable of doing it. This may not be your spouse. This may not be your daughter. This may not be your son. This may be your neighbor, your friend. They have to be able to understand what your wishes are. My sister has told me, if I'm in a terrible accident, keep me on life support. I'm not going anywhere. And I have told her, if I'm on life support, pull the plug. I can't, Jeannie. Well, she's not going to be the person I choose to be my health care proxy for my advance directive. Is that right?
Absolutely. Absolutely.
So we're running out of time. Let's talk about the top 3 things people need to know about getting advance directives in order.
Okay. One, we've talked about before. Make sure you're choosing the right person, somebody who's able to carry out your wishes. 2, communicate with them. Tell them. Have that conversation before you name them. This is what I want to do. Are you
Make sure
willing
they can
to
do it?
Exactly. What I encourage my clients to do is I give them their document. I say, go talk to the people you've named as your agents and make sure that they're in line with your wishes and they're going to be able to do this. If not, let's change it.
And give them a copy.
Absolutely.
Because if something happens to you, someone's got to be able to find it.
Yeah, and that's the third item of importance is make sure that those people named all have copies of it.
And even your doctor.
Yes, doctors and the hospital, if you're going in for a procedure, they're going to want it. So they're going to make you make one right there if you don't have one, so take it with you.
Such important information. Thank you so much for joining us today, Barbara. I really appreciate it, and I think we've given some great advice. You've given some great advice to the folks that are listening, so thank you.
Thank you. It's been a pleasure.
All right, folks, again, if you don't have a plan in place, please contact Barbara today, and you can call her at 678-880-0800, or you can check out her website at www.attyparkerlaw.com. I'm Jeannie Pete. Thanks for listening. Have a blessed day and week ahead. And listen here, same time next week and every week. Homestead Hope Foundation is your resource for a healthy life. God bless.